Chapter 4 Medical, Legal, and Ethical Issues. The issue may be as simple as making sure that the patient will accept help or as complex as a terminally ill patient who refuses all care. You may also be faced with decisions such as, should I stop and help even though I am off duty? Or can I get sued if I stop to help outside of my ambulance district? Understanding of medical, legal, and ethical issues is an essential foundation for all emergency care. This knowledge may also reduce or prevent the legal liability that you may face as a result of calls. Scope of practice. The EMT is governed by many medical, legal, and ethical guidelines. This collective set of regulations and ethical considerations may be referred to as a scope of practice, which defines the extent and limits of an EMT's job. The skills and medical interventions that the EMT may perform, what you do to help the patient, are defined by legislation that varies from state to state. Sometimes different regions within the same state may have different rules and guidelines for their EMTs. Be sure you understand the rules and guidelines that govern your area. For example, an EMT in one area may be able to perform certain basic procedures and levels of care. In the adjoining region, EMTs may provide that care and also perform special advanced procedures. Your duty is to provide for the well-being of the patient by rendering necessary and legally allowed care as defined in the scope of practice in your area. Falling within your scope of practice are certain ethical responsibilities. The primary ethical consideration is to make patient care and well-being a priority, even if this requires some personal sacrifice. For example, there may be times when a patient feels cold, even in a hot climate. You may want to turn on the air conditioner in the ambulance, but you refrain out of consideration for your patient. Actions such as this may seem small, but mean a lot to the patient. The scope of practice, as the name indicates, describes the scope of the EMT's job, but does not define the standard of care, which is usually defined as the care that would be expected to be provided by an EMT with similar training when caring for a patient in a similar situation. Standard of care will be discussed again later in this chapter with regard to the concept of negligence. In general, scope of practice refers to what you should be able to do, while standard of care refers to what you should do in a particular situation and how you should do it. To be an effective EMT, you must maintain your skills and knowledge. This includes practicing until you have obtained confidence and mastery of the skills. After that, continuing education and recertification are necessary to maintain mastery. Every patient deserves the best care. Emergency care can be improved on the crew and agency levels as well as on an individual level. After a call, constructively critique both yourself and the crew. Accept suggestions from others to improve your skills, communication, and patient outcome. Participation in this kind of mutual critique is part of the process known as quality improvement. It should be practiced with the aim of maintaining the standards you would wish to have provided for yourself or someone in your family. During the rest of this chapter, you will learn about some specific aspects of the scope of practice. Patient consent and refusal. Consent, or permission from the patient, is required for any treatment or action taken by the EMT. Most patients or their families will have called for your assistance and will readily accept it. A simple statement such as, I'm Carla McGuire, an EMT from the ambulance. I'd like to help you, okay? Is enough to request consent. Most patients will respond positively. Express consent must be obtained from every conscious, mentally competent adult before providing care and transportation. The principle of consent may seem simple, but it often brings up complex issues in patient care. There are 3 types of consent: expressed, implied, and consent to treat minors or incompetent patients. Think like an EMT. Ethical dilemmas. Not all critical or difficult decisions you make will be clinical in nature. You may be faced with an ethical dilemma that will test your decision-making skills. For each of the following situations, describe how you would handle the situation. It may be helpful to list the options available to you in each case. Then choose the course you think best. Number 1. You are driving the ambulance to the hospital and listening to the conversation in the back between a paramedic and an EMT. You hear the paramedic say, "Oh no, I can't believe I just did that. I gave her 10 times the dose I was supposed to." You hear the paramedic ask the EMT not to tell anyone. What do you do? Number 2. You are on the way home from a sporting event. While there, you had 2 drinks. You come across a crash with injury. What do you do? Number 3. A patient tells you that he received the injury you are treating while climbing a fence after being involved in a break-in at a local business. The patient swears he was just the lookout, and if anyone knows he told, he may be killed. What do you do? Express consent. The consent given by adults who are of legal age and are mentally competent to make a rational decision with regard to their medical well-being must be obtained from all patients who are physically and mentally able to give it. Express consent must be informed consent. That is, patients must understand the risks associated with the care they will receive. It is not only a legal requirement, but also appropriate emotional care to explain all procedures to the patient. Children and mentally incompetent adults are not legally allowed to provide consent or refuse medical care and transportation. The parents and guardians of these patients have the legal authority to give consent, so it must be obtained before care can be given. There are times, however, when care may be given without the direct consent from a parent or guardian. One situation where care may be given without direct consent from a parent or guardian involves a child care provider or school authority who may act in loco parentis in place of a parent when the parents are not physically present. Parents may provide written documentation to these individuals, allowing them to act in their absence. In cases of life-threatening illness or injury, when a parent or guardian is not present, care may be given based on implied consent. The law provides that it is reasonable to believe that a responsible parent or guardian would consent to care if the patient or guardian were present. In some states, statutes allow emancipated minors, those who are married or of a certain age, to provide consent. Finally, minors who themselves have children and those who serve in the armed forces may also be able to provide consent for their own care. Find out the laws where you will practice as an EMT in reference to the consent of minors. Implied consent. In the case of an unconscious patient or one who may be physically or mentally incapacitated but in need of emergency care, consent may be assumed. The law states that rational patients would consent to treatment if they were conscious. This is known as implied consent. In this situation, the law allows EMTs and other healthcare providers to provide treatment, at least until the patient becomes conscious and able to make rational decisions. Involuntary transportation. This is frequently the result of a decision made by police officers or mental health workers when they believe patients pose a threat of harm to themselves or others. Patients may also be transported against their will as a result of a court order. In some of these cases, you will be transporting patients who are physically restrained. This is a significant legal responsibility. Many lawsuits alleging negligence are brought against EMS providers for improper restraint or for harm caused to patients during restraint or transport. When a patient has been denied the ability to move freely, it is a great responsibility for the EMT to ensure the patient's health and well-being during this time. It is essential to frequently and thoroughly monitor the patient's mental status and vital signs while the patient is in your care. Restraint is discussed in two other places in this text. The chapter titled Lifting and Moving Patients and the chapter titled Behavioral and Psychiatric Emergencies and Suicide. When a patient refuses care. You may think that all patients who need medical care will accept it. Most do. However, you will find that some patients who require treatment or transportation to the hospital will refuse care. Many reasons for this, including denial, fear, failure to understand the seriousness of the situation, and intoxication. Although patients generally have the right to refuse care, it is your responsibility as an EMT to be sure that patients are fully informed about their situation and the implications of refusing care. In order for patients to refuse care or transport, several conditions must be fulfilled. Patients must be able to legally consent. They must be of legal age or emancipated minors. Patients must be awake and oriented. They must not be affected by any disease or condition that would impair judgment. These conditions include unstable vital signs, alcohol intoxication, or the influence of drugs and altered mental status. Patients must be fully informed. They must have the mental capacity to understand their situation and the potential consequences of refusal of care. Patients will be asked to sign a release form. Such a form is designed to release the ambulance agency and individuals from liability, arising from the patient's informed refusal. Even carefully following these steps will not guarantee that you will be free from liability. If a patient refuses care or transport, leaving a patient who will not accept care or transport is a leading cause of lawsuits against EMS agencies and providers, even though it was the patient who refused. Occasionally, the patient's condition deteriorates to the point of unconsciousness, which leaves the patient unable to summon help, leading to severely worsened condition or even death. In addition to the liability factor, there is also an ethical issue. You would undoubtedly feel guilty if a patient were found unconscious or deceased after refusing care, and you felt that transportation would have prevented the circumstance. If in doubt, do everything possible to persuade the patient to accept care and transport. Take all possible actions to persuade a patient you feel should go to the hospital, but who refuses to go. These actions may include: spend time speaking with the patient. Use principles of effective communication. It may take some reasoning, persistence, and dealing. We'll call a neighbor to take care of your cat, but then you go to the hospital. Or another strategy. Listen carefully to try to determine why the patient is refusing care. Often the patient has a fear of the hospital, procedures, prolonged hospitalization, or even death. Refusal to go to the hospital may be a form of denial or unwillingness to accept the idea of being ill. If you identify the cause of the refusal, you may be able to develop a strategy to persuade the patient to accept your care and transportation to the hospital. Listening to the patient is the key to determining why the patient is refusing. Inform the patient of the consequences of not going to the hospital. This is an essential component of every refusal of care situation. For example, in the case of patients who you believe may be having a heart attack or other potentially life-threatening condition refusing transport, it is appropriate to tell the patients that they may get very ill or die without treatment. If these patients still refuse, you should stress the importance of transport to an emergency department and tell the patients that death may result without treatment. Consult medical direction. If you are in a residence, use the phone to contact medical direction. If the online doctor is willing, let the doctor speak to the patient when all else fails. Many services require physician contact before accepting a refusal under these circumstances. Ask the patient if it is all right if you call a family member, or advise the patient that you would like to call a family member. Often, family members can provide the patient with reasons to go to the hospital. An offer from a loved one to meet the patient at the hospital may be very helpful. Note, however, that notifying others and sharing protected information against the patient's wishes may constitute a violation of privacy law. If you ask for permission or if you advise the patient of your intention to call a family member and the patient either agrees or does not object, this constitutes consent. As part of your call's documentation, you should document that this permission to speak to the family was verbally granted to you by the patient. Be sure you understand your agency's policy on how to handle this issue. Call law enforcement personnel if necessary. Police may be able to order or force patients who refuse care to go to the hospital. This is done under the premise that patients might be temporarily mentally incompetent, as demonstrated by refusal of potentially life-saving care. Be very sure that there is evidence of incompetence, because you are assuming possible legal liability if you're wrong. Remember that a patient is not mentally incompetent just because they refuse life-saving care. Again, be sure you understand your agency's policies on this issue. Ask the patient to sign the refusal of care form used by your agency. Sometimes a patient will refuse to sign these forms. If the patient refuses to sign the form, you should specifically document in your own patient care report that you carefully explain the risks and consequences of refusal to the patient and that the patient had the capacity to understand your warnings, but still decline to sign the form. Always bear in mind that you do not have the right, in most cases, to force patients with appropriate mental capacity to go to the hospital against their will. Subjecting patients to unwanted care and transport has actually been viewed in court as assault in some instances and battery in others. If all efforts fail and the patient does not accept your care or transportation, it becomes vital to document the attempts you made. Make your efforts a part of the official record in order to prevent liability. Write into your records every step you took to persuade the patient to accept care or go to the hospital. Include the names of any witnesses to your attempts and the patient's refusal. In all cases of refusal, you should advise patients to call back at any time if they have a problem, or wish to be cared for or transported. It is advisable to call a relative or neighbor who could stay with the patient in case problems develop. If the local emergency number is not 911, make sure the patient knows the number to call. You should also recommend that the patient or a relative call the family physician to report the incident and arrange for follow-up care. Document all actions you have taken for the patient. Although there may be patients who legitimately refuse care for minor wounds, unfounded calls, and the like, a patient with any significant medical condition should be transported and seen at the hospital. Point of view. My wife said I passed out. I don't remember passing out. To be honest, I don't remember much about it at all. I woke up and the aliens was there. They said they'd take me to the hospital if I wanted. Who wants to go to the hospital? Not me, that's for sure. My parents died in the hospital. My brother died at the hospital. The best thing I could do was stay out of the hospital. My wife looked so nervous. She almost convinced me to go. The boys and the aliens. No, one of them was a girl. Nice kids. They put a computer in front of me. Wanted me to sign a little box on the screen. Not sure what. I can't hear much anymore anyway. They were telling me all kinds of things in big medical words. At my age, what difference does it make anyway? So I signed it. Do not resuscitate orders and physician's orders for life-sustaining treatment. It will only be a matter of time before you come upon a patient who has a do not resuscitate DNR order. This is a legal document, usually signed by the patient and the patient's physician, which states that the patient has a terminal illness and does not wish to prolong life through resuscitative efforts. A DNR order may be part of an advance directive, because it is written and signed in advance of any event where resuscitation might be undertaken. It is more than express wishes of the patient or family. It is an actual legal document. A DNR order may also be part of a physician's order for life-sustaining treatment, POLST. Typically include not just whether patients wish resuscitation attempts, but also whether patients wish artificial feeding or antibiotics if unable to express their desires later. These forms will often specify on the front page whether patients wish resuscitation attempts. Some states may have variations on this form that allow a provider or clinician, such as a physician assistant or advanced practice nurse, to validate the form. This is an area that is evolving, so keep an eye on what is occurring in your state. There are varying degrees of DNR orders, expressed through a variety of detailed instructions that may be a part of the order. Such an instruction might stipulate, for example, that resuscitation be attempted only if cardiac or respiratory arrest is observed, but not attempted if the patient is found already in arrest, to avoid the possibility of resuscitating a patient who may have already sustained brain damage. Many states also have laws governing living wills, which are statements signed by the patient, usually regarding use of long-term life support and comfort measures such as respirators, intravenous feedings, and pain medication. Other states require naming of proxy, a person whom the signer of the document names, to make healthcare decisions in case the signer is unable to make those decisions. Living wills and healthcare proxies usually pertain to situations that will occur in the hospital rather than in the pre-hospital situation. Become familiar with the laws regarding DNR orders, living wills, and healthcare proxies for your region or state, and the laws and rules governing their implementation. It's important to know the forms and policies before you go to the call, since often the patient is in cardiac arrest, heart and breathing have stopped, or near death. These are stressful times for the family and for you. Occasions when the window of time for making a resuscitation decision may be only a few moments. A legal DNR order prevents unwanted resuscitation in awkward situations. In most cases, the oral requests of a family member are not reason to withhold care. If the family requests you to not resuscitate the patient, and if there are no legal DNR orders available, it is a legal and ethical dilemma that is usually best resolved by providing care. It is better to be criticized or sued for attempting to save a life than letting a patient die. At times, a family member under duress may ask that a DNR order be ignored and resuscitation be initiated, despite the DNR. In such a situation, contact medical direction for advice, and if necessary, ask the medical direction physician to speak directly to the family. Other legal issues. Negligence. To the lay person, negligence means that something that should have been done was not done or was done incorrectly. The legal concept of negligence in emergency care is not that simple. A finding of negligence or failure to act properly requires that all of the following circumstances be proved. The EMT had a duty to the patient. Duty to act. See the next section. EMT did not provide the standard of care. Committed a breach of duty. This may include the failure to act. That is, the EMT did not provide needed care as would be expected of EMT in the relevant locality. Failure to act is a major cause of legal actions against EMS systems or EMTs. There was proximate causation. This means that by not providing the standard of care, the EMT caused harm to the patient. The harm can be physical or psychological. An example of proximate causation would be injuries caused when EMTs drop the stretcher carrying a patient. This concept cannot be applied to patients who are seriously injured and cannot be saved. If you perform CPR according to guidelines and the patient dies, there is no proximate causation between your actions and the patient's death. Negligence is the basis for a large number of lawsuits involving pre-hospital emergency care. If the previously listed circumstances are proved, the EMT may be required to pay damages if the court considers the harm to the patient to be a loss that requires reimbursement. The negligent EMT may be required to pay for medical expenses, lost wages, pain and suffering, and various other factors as determined by the court. Proceedings or lawsuits against EMTs are usually classified as torts. A tort is a civil offense as opposed to a criminal offense resulting in arrest. A tort may be defined as an action or injury caused by negligence from which a lawsuit may arise. The concept used in tort law is res ipsa loquitur, a Latin term meaning the thing speaks for itself. This is a foundational concept in negligence because it allows the finding of negligence even when there is no specific evidence of a negligent act. Looking back at the stretcher drop example in which the patient was injured, the plaintiff would not have to prove a specific intent or negligence on the part of the EMTs, or even that the EMTs were the ones who caused the stretcher to drop. Since the EMTs had exclusive control over the stretcher when it was dropped, there is a reasonable assumption that the EMTs caused the accident and that without negligence of some sort, the accident would not have happened. Two of the most common and significant causes of lawsuits against EMTs are patient refusal and ambulance collisions. In patient refusal situations, EMTs are sued because the patient's condition deteriorated after the ambulance left the scene. This makes it critical to follow your agency's guidelines when a patient refuses care. Collisions are dangerous in any vehicle. When an ambulance is involved, collisions become serious because of the size and weight of the vehicle, the number of occupants, including the patient, and the nature of emergency driving. It is important to remember that most collisions are preventable. This is why they are no longer referred to as accidents. Emergency driving must always be done responsibly. Lawsuits against EMTs are uncommon, especially in light of the number of calls that are dispatched each day in this country. Although liability and negligence should be important considerations, you should not live or work in fear of a lawsuit. When you perform proper care that is within your scope of practice, and you document that care properly, you will prevent most, if not all, legal problems. Duty to act. An EMT in certain situations has a duty to act, or an obligation to provide emergency care to a patient. An EMT who is on an ambulance and is dispatched to a call clearly has a duty to act. If there is no threat to safety, the EMT must provide care. This duty to act continues throughout the call. If an EMT has initiated care, then leaves the patient without ensuring that the patient has been turned over to someone with equal or greater medical training, abandonment has occurred. Similarly, if a paramedic has begun advanced care and then turns the patient over to an EMT for transport, abandonment on the part of the paramedic may exist. The duty to act is not always clear. It depends on your state and local laws. In many states, an off-duty EMT has no legal obligation to provide care. However, you may feel a moral or ethical obligation to act. For example, if you observe a motor vehicle collision while off-duty, you may feel morally bound to provide care, even if no legal obligation exists. If you are off-duty, you decide to begin care and then you leave before other trained personnel arrive. You may still be considered to have abandoned the patient. Other situations are even more confusing. If you are an EMT in an ambulance, but you are out of your jurisdiction, the laws are again often unclear. In general, if you follow your conscience and provide care, you'll incur less liability than if you do not act. Always follow your local protocols and laws. Your instructor will provide information about local issues. Good Samaritan laws. Good Samaritan laws have been developed in all states to provide immunity to individuals trying to help people in emergencies. Most of these laws will grant immunity from liability if the rescuers act in good faith to provide care to the level of their training and to the best of their ability. These laws do not prevent someone from initiating a lawsuit, nor will they protect rescuers from being found liable for acts of gross negligence or other violations of the law. Just familiarize yourself with the laws that govern your state. Good Samaritan laws may not apply to EMTs in your locality. In some states, the Good Samaritan law apply only to volunteers. If you are a paid EMT, different laws and regulations may apply. Some states have specific statutes that authorize, regulate, and protect EMS personnel. Typically, to be protected by such laws, you must be recognized as an EMT in the state where care was provided. Some states have specific licensing and certification requirements that must be met for recognition under Good Samaritan laws. Confidentiality. When you act as an EMT, you obtain a considerable amount of information about a patient. You are also allowed into homes and other personal areas that are private and contain much information about people. Any information you obtain about a patient's history, condition, or treatment is considered confidential and must not be shared with anybody else. This principle is known as confidentiality. Sensitive information may be disclosed only when a written release is signed by the patient. Your organization will have a policy on this. Patient information should not be disclosed based on verbal permission, nor should information be disclosed over the telephone. However, you may be subpoenaed or ordered by legal authority into court where you may legally disclose the patient information. If you have a question about the validity of a legal document, contact a supervisor or your agency's attorney for advice. Patient information also may be shared with other healthcare professionals who will have a role in the patient's care or in quality improvement. It is appropriate to turn over information about the patient to the nurse and the physician at the receiving hospital. This is necessary for continuity in patient care. It may also be necessary and permissible to supply certain patient care information for insurance billing forms. Although confidentiality has always been a part of healthcare, federal regulations give it even greater emphasis. The Privacy Rule of the Health Insurance Portability and Accountability Act, HIPAA, has specific requirements for record keeping, storage, access, and discussion of patient-specific medical information. EMS agencies that bill for services electronically or by employing a private company that does this work are mandated to have policies, procedures, and training in place to deal with these privacy issues. Special situations. Libel and slander are two legal terms that may apply when information is shared inappropriately or falsely. Libel is when information that is false and injurious to another is spread in written form. Slander is when the information is shared verbally. The Privacy Rule of the Health Insurance Portability and Accountability Act, HIPAA. When you go through ambulance orientation or when you begin to work or volunteer, you will likely hear much about HIPAA regulations. These federal regulations are designed to limit access to records by unnecessary personnel, as well as to provide patients the right to review their information and have a greater say in its use and distribution. How will this affect you as an EMT? You will discuss patient-specific information only with those with whom it is medically necessary to do so. Your EMS agency will have specific privacy policies and procedures in place. You will get a printed copy of these policies and procedures, as will the patients in your care. You'll ask your patients to sign a form indicating they have received this information. This form may be combined with your insurance release form. EMS agency will have a privacy officer to oversee HIPAA issues and deal with the documentation required by law. Remember that you will be provided information about your agency's specific privacy policies and procedures. Medical identification devices. Patients may wear a medical identification device to alert EMTs and other healthcare professionals that they have a particular medical condition. Then, if a patient is found unconscious, the device provides important medical information. The device may be a necklace, bracelet, or card. The medical identification jewelry available today is quite stylish and may not always look like the traditional oval bracelets many are familiar with. Medical identification devices may indicate a number of conditions including allergies, diabetes, epilepsy. It is becoming increasingly common to see patients with tattoos that identify their medical condition. If you see a tattoo that appears to identify a medical condition, you should treat it like a medical identification device and explore how that condition relates to the patient's presentation. Tattoos do have a few issues. Unlike medical identification devices, tattoos cannot be removed if a medical condition changes or is cured. Also, EMTs may not think to look for tattoos as they would for medical identification jewelry. Remember to be alert for medical tattoos as you assess patients. Finally, some organizations distribute systems for medical identification that are stored in the patient's residence, sometimes called File of Life or Vial of Life. These systems ask a patient, often a senior citizen, to affix a sticker to the outside of the residence indicating that the medical information is stored inside, often on the refrigerator or in another specific and clear location. This system is dependent on the patient or family members keeping the information up to date. Be sure to verify the information found with the patient or family members. Organ donors. You may respond to calls where a patient is critically injured, perhaps near death, and is an organ donor. An organ donor is a patient who has completed a legal document that allows for donation of organs and tissues in the event of death. Many people have benefited from the donation of organs by persons who have completed this paperwork. You may learn that the patient is an organ donor when told so by a family member. Often, an organ donor card is kept in a patient's wallet. The patient's driver's license may also contain indication that the patient wishes to donate organs at the time of death. The emergency care of a patient who is an organ donor must not differ from the care of a patient who is not a donor. All emergency care measures must be taken. If a patient is recognized as an organ donor, contact medical direction. The online physician may order you to perform CPR on a patient when you might normally not resuscitate due to fatal injuries. Oxygen delivered to body cells by CPR helps preserve organs until they can be harvested for implantation in another person. Safe haven laws. Most states have implemented some sort of safe haven law. Under such a law, a person may permanently leave an infant or child at any police, fire, EMS station, or deliver the patient or child to any available public safety personnel. Each state has different guidelines for the ages of children included under the Act, usually infants to young children. Crime scenes. A crime scene is defined as the location where a crime has been committed or any place where evidence relating to a crime may be found. Many crime scenes involve crimes against people. These crimes cause injuries that are often serious. Once police have made the scene safe, the EMT's priority at a crime scene is to provide patient care. While you're providing care at the crime scene, there are actions that you can take to help preserve evidence. To preserve evidence, you must first know what evidence is, as described in the following list. Condition of the scene. The condition in which you find the scene is important evidence to the police. If you arrive first, make a mental note of the exterior of the scene. Remember how you gained access. Doors found ajar, burn marks, and broken windows are signs of danger for you and important evidence for the police. Make note of whether the lights were on or off and of the condition of the TV and radio. The patient. The patient often will provide valuable information. The position, condition of clothing, and injuries of the patient are all valuable pieces of evidence. Fingerprints and footprints. Fingerprints are perhaps the most familiar kind of evidence. They may be obtained from almost any surface. It is important for you to avoid unnecessarily touching anything at the scene in order to preserve prints. Wearing gloves at the scene will prevent you from leaving your fingerprints on objects. If you touch these objects, however, even while wearing gloves, you may smudge fingerprints that were left by someone else. Microscopic evidence. Microscopic evidence is a wide range of evidence that is usually invisible to the naked eye. It consists of small pieces of evidence such as dirt and carpet fibers. To the eye, there may be no way to distinguish one from the other. Through a microscope, scientists can develop valuable information. Just a few fibers, the materials and sometimes the brand name of carpets or clothes can be determined. Traces of blood may be enough to determine blood type or to be used for DNA comparison. To preserve evidence of the crime scene, the following actions will be helpful to the police. Remember that your first priority is always patient care. Remember what you touch. It may be necessary to move the patient or furniture to begin CPR or other patient care. Although this cannot be avoided, it is helpful to tell the police that what you have touched or moved. Once you leave, if they find furniture moves or bloodstains in two locations, they may think that a scuffle took place when in fact it did not. If you are forced to break a window to get to the patient and do not tell the police, they will think that a breaking and entering has occurred. Minimize your impact on the scene. If you are forced to move the patient or furniture to begin care, move as little as possible. Do not wander through the house or go to areas where it is not necessary to go. Avoid using the phone, which otherwise would prevent the police from using the redial button to determine the victim last called. Do not use the bathroom, since this may also destroy evidence. Do not cut through holes left in the clothing by bullets or knives, which will also destroy evidence. But at least 6 inches, about 15 centimeters away from these holes. Work with the police. The police may require you to provide a statement about your actions or observations at the scene. Although it may not be possible to make notes while patient care is ongoing, after you arrive at the hospital, make notes about your observation and actions at the scene. You may also wish to critique the scene. both with your crew and, if possible, with the police. Invite a member of your local or state police department to your agency for an in-service drill on crime scenes. Evidence recovery methods and procedures vary from area to area. The police officer who comes to your station will brief you on local procedures. Interestingly enough, police are often as unfamiliar with EMS procedures as you are with police evidence procedures. Police may ask you to delay your work at the scene so they can take photographs or interview the patient. They may do this because they do not understand, as you will learn in later chapters, that in the case of serious injury, the time that elapses before on-scene care and transport to the hospital must be kept to a minimum for the patient to have the best chance of survival. Education and critiques can be beneficial to both EMTs and police officers. Special reporting requirements. Many states require EMTs and other healthcare professionals to report certain types of incidents. Hotlines exist in many areas for reporting crimes such as child, elder, or domestic abuse, or suspicion of human trafficking. These topics are discussed in the chapter Emergencies for Patients with Special Challenges. Reporting may be mandatory in your area, and failure to report certain incidents may actually be a crime. Beyond this, there is a strong moral obligation to report crimes against vulnerable, at-risk populations. Many states offer immunity from liability to people who report such incidents in good faith. Other crimes may also require reports. Violence, such as gunshot wounds or stabbings, and sexual assaults also fall into this category. If you are required by law to report such incidents, you are usually exempt from confidentiality requirements. You may also be required to notify police of other situations, such as cases where restraint may be necessary, where intoxicated persons have been found with injury, or where mentally incompetent people have been injured. Other ethical responsibilities. Many of the topics discussed in this chapter have both legal and ethical implications, but there are a few topics that still need to be addressed. Morality refers to personal opinions and beliefs about what is right and wrong. Ethics, when speaking about a profession, refers to standards of behavior for those who practice that profession. Some of the ethical expectations for an EMT include being honest in reporting, refraining from actions that cause harm to a patient. It's obvious, but another way to think of this is to say that if you're going to make a mistake, make it a reversible one. For example, when in doubt about whether to start CPR, it is generally better to start and then stop after more information is available than to refrain initially and start CPR later, when it is much less likely to be effective. To help the patient, which includes putting the patient's interests above your interests and comfort. Respecting the right of adult patients to make decisions on their own behalf when they are informed and able to make decisions. Treating all patients fairly and justly without regard to sex, race, ability to pay, and other conditions as described by law and ethical codes. Assisting others as appropriate to learn your profession. This does not mean you have to become an EMT instructor or a preceptor. But once you become an EMT, you should deal with EMT students in a fair and respectful manner, reporting misconduct that affects or may affect patient care, making sure, if you participate in research, that it is approved by the appropriate authority and that you understand it well enough to avoid inflicting harm. Chapter 4.